Hello and welcome everyone, and thank you for joining us for COVID-19 Preparedness and Management. Throughout the presentation, please type your questions into the Q&A feature found on the right side of your screen. We will reserve about 10 or 15 minutes to answer your questions after the presentation. We also invite you to use the chat to engage with each other, but please keep in mind to put all your questions for the presenter into the Q&A feature. I would like to thank all the Ag Labor Forum sponsors for their support, and also our presenter today, Seth Mehrten with Barsamian and Moody. Seth is an associate attorney with Barsamian and Moody. He represents employers in state and federal court and various state and federal administrative agencies, including the National Labor Relations Board, U.S. Department of Labor, Fair Employment and Housing Commission, Equal Opportunity Commission, California Labor Commissioner, and the OSHA Appeals Board. He has extensive experience defending agricultural employers in complex wage and hour class and representative actions, as well as defending employers against other claims, such as wrongful termination, harassment, discrimination, and retaliation. And Seth, the floor is yours. Thank you for being here.
Thank you, Julia, and thank you for everybody for being a part of this session. I'm excited to be with you all today. As you know, we're talking about COVID-19 preparedness and management and kind of all the steps to take in relation to prepare to manage and continue dealing with this thing that just doesn't feel like it's going away anytime soon. So, whether we like it or not, we've got to figure out how to prepare and manage for this virus in the workplace. Before we get started, I just want, and I'm sure everyone's had a ton of these throughout the course of these 2 days, but I just want to throw a legal disclaimer out there that while we're going to be talking about some laws, regulations, and giving some practical advice about what to do, in the context of this presentation, I'm not your attorney, so what I say and kind of advise on is not specific advice tailored to your situation. And Julia, I'm getting some comments in the chat that folks are unable to see anything. Is that something that everybody's experiencing? Because if it is, I want to deal with it now.
Can you please put in the comment if you're able to hear us and see us, and if you can see the presentation? My chat is, actually I don't see anything. Can you please put in the comment box that you can hear us and see us?
Okay, sounds like everybody can hear but can't see. Let me see if we can figure out how to get. All right, did that solve the problem? It says on my end that everybody can see, but it doesn't seem like you all can see me. Okay.
I'll be right back. I'm going to ask for technical support.
Okay. I'm going to go ahead and in the interest of time, I'm going to go ahead and get started. I think we can always, once we're able to get the PowerPoint up and running, we can do that. I apologize for the inconvenience. So as I was saying, while we're going to give some specific things to do today, some advice, it is not advice that is tailored to your individual situation. So it's not legal advice. This is a really, it tends to be a nuanced area of law, and it's a developing area of law. So if there are things that you're dealing with, you have specific questions about, you're more than welcome to reach out to me, but I'll direct you kind of either to me or another labor attorney to get specific advice on particular things that you might be dealing with. So throughout today's presentations, one of the things that I want to make sure you take away from this is that as just sort of if we back up before we ever even get into talking about the different requirements with regard to all of the new COVID-related type regulations and laws. The thing I want you to remember and just sort of have in the background of your mind is that labor and employment laws are always going to be interpreted in the way that's most favorable to the employee or most beneficial to the employee or most restrictive to the employer. So anytime you're thinking about this stuff and kind of come to a fork in the road, you think, okay, there's one of two ways I can go, or there's a bunch of different ways, there's a huge gray area, I'm not really sure what to do. You're guiding light in this, and it may be a frustrating guiding light, right? If you're trying to deal with operational demands and making a profit, your guiding light should be what's going to be most beneficial to the employee. And while in the short run, that's going to be really frustrating because it might present some operational challenges to you. It might involve some increased costs. There may be downsides from that perspective on the front end of things. On the back end, when we're talking about mitigating your risk and your liability for this sort of stuff, that's going to be the way that you're going to do it best, because courts and certainly administrative agencies, Cal OSHA, labor commissioner, when they're looking on at decisions that you've made with regard to how to manage and prepare for COVID, they're going to be asking themselves, did they do where there wasn't clear guidance? Did they do what was most beneficial for the employee? So that's just sort of the golden rule in employment law, and the thing I want you to kind of keep in the back of your mind. All right, so I think we've got the presentation up now. Are you all able to see that? So if you can see the presentation now, just do us a favor and.
Seth, can
good.
You
All right.
again? It just went away again.
Oh, it did go away.
Mm-hmm.
There might be some sort of a delay because now I'm seeing everybody say that they can see it. Okay, we've got a lot of information. So if we can have a PowerPoint, I think everybody will be aided by that, as opposed to just getting the information through my speech. Can everybody see the presentation there? And Julie, at this point, I can't see the chat feature, so if you can help me to know whether folks are indicating that they can see the PowerPoint now, that'd be helpful.
I can see your PowerPoint, but it's not in the presentation format. Maybe you can just make the slide a little bit bigger and just go from there and click the slides on the sidebar. Yes, people can see the presentation.
Is that better? Can you now see the presentation and not the presenter view?
Someone said that it's in safe mode, that it needs to be off the safe mode. just disappeared. Seth, let me try to do this screen share.
Well, I think in the interest of time, I think I'm just going to go ahead and continue on. All right, I think I'm just going to continue on. And if at some point we can figure out how to share slides, awesome.
Hey, Julia. It's up, Julia.
Okay, so
hi. You just popped in. It's up. The presentation is showing.
Okay. And Seth, what slide would you like me to go to?
Go ahead and go to the fifth slide. It'll say where to start at the top. So let's start with preventative measures. So just kind of as a baseline, I know that there's been an inordinate amount of guidance that's come in from every conceivable agency, be it federal, state, local, laws, regulations, the whole bit. We've had counties weigh in and cities weigh in. There's been a lot of guidance, but I also realize that when you're drinking from the fire hose of guidance, there's a lot that can get lost in that, and it becomes difficult to realize or to understand where you should be focusing, where you should be looking at for guidance. Some of the guidance initially, I think early on, there was guidance that was, some was duplicative and it was one-to-one, it matched up and synced up really well, but there was other guidance that didn't. And so I know a lot of folks just became confused about, one agency says do this, another agency says do this. This law appears to encourage this, but another law, prohibits this. There was kind of, conflict between what do wage and hour laws require versus what do privacy laws prohibit or restrict versus what do safety laws demand. So there's a lot of confusion about that. I think by and large, the guidance tends to be kind of trending all in the same direction now. So I think to a certain extent, it should be a lot easier than it was initially to get good information and good guidance about, and really consistent guidance about what your obligations are as employers for keeping your workforce safe and your workplace safe. That said, if for whatever reason you're just kind of starting out or you're still trying to get a feel for this, I think that you're best served by starting local to an extent. So start at the state level with the California Department of Public Health. There is some recent guidance that they've put out. That guidance will direct you to two general places. One, it's going to direct you to some federal guidance that's being put out by the CDC. And I've got links here on this slide for that guidance document, but it's kind of the initial, or one of the initial documents that was put out by the CDC. And then the state's also going to direct you and really heavily rely on CalOSHA. Now, these three entities are all kind of using and piggybacking off of one another's definitions and their standards and their guidance. So, for the most part, you shouldn't find guidance in these documents that are going to be in any way, conflicting or contradictory. So, again, start with the state, CDPH, and then work your way down and kind of look at some of the baseline documents for CDC and CalOSHA. Go ahead and advance slides. So, in particular with CalOSHA, they've put out what they're calling the employer playbook, and that is the guide. It's expressly deemed the guide for reopening your business, but it's also just a guide for, I think of it as kind of the guide for staying open, for supporting your business while you're continuing to operate. So don't just think of it as the guide for reopening, but really the guide for continuing to open or be open. One of the things that's nice about OSHA is that they have gone through and they've now created, I believe it's 34 or 35 different sets of guidance documents specific to industries. So there are now industry guidance documents that are specific to ag and specific to food packing and processing facilities. So depending on what you are, and as FLCs, a lot of you are going to be kind of looking at that ag guidance. There are, in addition to the industry guidance, there's also, they put out general and daily checklists. And for the most part, a lot of the information is going to be duplicative. So, to the extent that you're crunched for time, or just, are kind of overwhelmed by all this, just by going through the initial guidance documents for ag, you're going to be able to pick up a lot of what you should be doing, and what will be then kind of repeated or refreshed in the general and daily checklist. So just kind of keep that in mind. I think at this point we've kind of all heard everything, but I think it's easy in the context of trying to create a really thorough and comprehensive list of things that you're making sure you're doing. Crossing every T, dotting every I. It can be easy to forget some of the things that you're supposed to be doing. Go ahead and advance slides, Julia. So in terms of some of the baseline preventative measures, one of the things that Cal OSHA is requiring is you've got to have this written plan. When we think about being able to show Cal OSHA and any other administrative agency, or even if a plaintiff's attorney was looking into the way that you're keeping employees safe, you want to be able to have something to provide them to show them that you've thought about your operations, you've assessed the risk, and you've made some conscious decisions about how to address them. It's one thing to be able to kind of speak to it, but it's another thing to show somebody that you've taken the time to reduce it to a writing. So you want to make sure that you've got a specific plan that's unique to you. It's not something that you just went and downloaded off of the internet, Googled great injury illness prevention plan, and then just put that into place. You really want it to be something that speaks to your specific operations. Who's responsible for implementing this plan? What particular person, or maybe title? Are there particular areas within your workplace that pose particular problems? When you start getting down into the control measures that you're going to be taking, you really want those control measures to be tailored to your business. So if there's particular areas that pose problems, maybe because they all funnel in through the same entry and exit, are there things that you can do to mitigate that risk? There are, particular policies that you have. One of the things you need to do with the policies is be thinking about what unintended consequences do these policies create. One of the places that I think we're going to see increased lawsuits and certainly labor commissioner claims is in the way that these policies can have kind of unintended consequences on wage and hour compliance. So if you've got employees who are being required to take their temperature before they're entering your premises, if there's employees that are required to go through kind of a lengthy self-monitoring protocol before they leave the home. While those are great safety protocols and great safety measures to introduce, you have to then think about the ways that they impact you from a wage and hour standpoint. So if you have piece rate workers and you don't or are not accounting for other non-productive time for things like standing in line to get your temperature taken, or even something as simple as just, hey, we've got to check in the morning and walk through this checklist that my employer gave me. There's at least an argument there that those are things that would be kind of falling under a required work activity that needs to be compensated under that obligation to pay at least minimum wage for all hours worked. So, don't just make the assumption that because you're implementing Cal OSHA's guidance or CDC's guidance or CDPH's guidance that you're automatically going to be in compliance with wage and hour laws. Those agencies don't have a a full command of all wage and hour requirements and the way that they're going to apply to your business. Their focus is going to be safety and keeping people, free of this virus. So they're not going to be thinking about making sure everybody is compensated in the way that they're required to be compensated. It's certainly not for something as specific and nuanced as California's piece rate requirements. So just kind of think through that. Initially, the first kind of wave of litigation we saw was with respect to the reimbursement claims that some of the app-based companies dealt with. I don't know necessarily how many more of those we're going to see. I think a lot of employers have shifted now to avoiding those types of claims by making sure that they're providing things like hand sanitizer, and certainly you want to be providing all of the things for good hand hygiene. But other safety equipment like face coverings, for example, is one of those things that initially the employers were on the fence about providing, but I think now there's general consensus that it's best practice to be providing that, if for no other reason than you want to be able to shore up any liability you have with a wage and hour lawsuit for a failure to reimburse employees for unnecessary business expense. So really think through those policies that you're implementing from a safety perspective. Think about how they can have impacts on particularly wage and hour liability. And then, of course, you want to train employees. I think it's one thing to have the policy reduced to a writing. It's one thing to have management be prepared to kind of implement the policy, but you really want to communicate your policy and communicate the expectations to employees. A huge portion of this, and responding to COVID in the workplace, preventing it in the workplace, a huge portion is relying on your individual employees to be diligent enough to flag potential issues for you and to give you the information that you need to be able to respond and address this stuff. So I think we really want to be training employees on all of the things that we're, as an employer, requiring in our specific workplace, but then also just all of the different obligations that kind of all employers everywhere have in terms of helping employees understand, what do symptoms look like, what steps can you take to protect yourself both in the workplace but also outside of the workplace, the importance of seeking medical attention and hand hygiene and physical distancing and wearing face coverings, all those things that employees are hearing. I think it's important for us to be able to show that we've been reinforcing that in the workplace and not just kind of allowing lackadaisical approach to it. And then I think the last thing you want to do is make sure you're constantly increasing buy-in from employees by soliciting feedback and kind of checking in and seeing how the process is working for them. It is often the case that wage and hour problems, be them labor commissioner claims or class action lawsuits or just private party wage and hour lawsuits, often the case that those start out as just simple employees frustrated about a safety procedure. They're frustrated that they feel like they weren't heard on a particular issue, or there's just some sort of a process that created friction in their workday, and so they thought, hey, I think I'll go to an attorney and ask about whether this is right or whether this employer is wrong. And in the process of that, plaintiffs' attorneys in California are pretty quick to turn employees onto, well, hey, that's an issue out there, and it might be able to yield some cash for you, but that's really not going to be as lucrative as one of these wage and hour claims. And so just be cognizant of that while we've got a global pandemic we're dealing with, we as California employers also have a very real kind of this constant threat from these wage and hour suits that's going to be devastating everybody. So keep that in mind. Go ahead and advance. So just a note, and it's really fresh, but if you weren't requiring face coverings, this just 2 days ago, I believe on the 16th, CEPH came down, and so now the state is going to be essentially mandating masks at any point when someone's outside of the home and unable to physical distance. So we're just going to keep that in mind. Certainly, if you've got employees that are carpooling and they should have already been wearing face masks, but to the extent that they're not, I think the state's kind of doubling down on that particular requirement. I think while initially everybody was focused on the transmission of the virus through maybe physical contact, I think now the general consensus seems to be that it's more focused on respiratory droplets that have the virus, and so that face mask or face covering requirement continues to be one of those things that I think the state's going to focus on, and so just kind of keep that in mind in your policies, that should absolutely be included as kind of a baseline mitigation measure. Go ahead and advance. So one thing that's going to be new as of January 1 is this whole idea that you've got to be with AB 685 reporting and giving notice of instances where employees have been exposed to a qualified individual. Now the definition is pretty limited. We're talking about people who've been, are either positive for COVID, have died due to COVID, or have been ordered by a public health officer to quarantine. And it's not we're not talking about the sort of general shelter-in-place orders. We're talking about a specific quarantine order or a quarantine order that is specific to a particular person. So if you've got one of those qualifying individuals, you would then potentially be in a position where you need to notify all the employees that might have been exposed to that person. So then that would be anybody that was in this place where the qualifying individual works during their infectious period. You'll notice that the infectious period it kind of looks back retroactively and predates the onset of the symptoms. So you're looking at 2 days prior to the onset of symptoms, and then you're kind of running through 10 days after. As we all know, though, if you've got somebody who is expressing symptoms, that right there should be enough for you to act quickly to get them out of the workplace. So the hope is that you're not having employees who are symptomatic on your premises, but in any event, this definition of infectious period is 2 days prior to the onset of symptoms and 10 days after. Now, that goes into effect January 1, but to a certain extent, we'll talk about this a little bit further down, but to a certain extent, you should have already been applying some of these principles in your preventative measures. Go ahead and extend, or go to the next slide. So Julie, if you can go down just go ahead and go to the next slide. So the requirement is that notice be provided in writing, and so I would imagine that many of you have received from our firm kind of a template 685 notice. If you haven't, feel free to contact us. We're happy to provide that to you. You should have, though, a process and a template in place that you can immediately provide this notice. So you've got 1 business day from the notice requirement being triggered. So once you've got employees who have told you, hey, I'm either positive for COVID, I've been instructed to quarantine, that you're going to need to be then immediately notifying your other employees. So this isn't the type of thing that you want to have to, when notified, begin working up a notice to notify their employees. We want to have that in place now. And so from a technical standpoint, you've got a little over a month to get that together. But I think the point is don't wait till January to start thinking about how to work up this notice.
Seth, you have a question on the notice from Lucas Sandoval, who's asking, What if there are workers who have low literacy? They cannot understand a written notice in any language.
That's a good question. My gut is that I haven't seen any particular guidance on that issue, but you are required to provide it in English and a language they understand. So if they don't understand, or can't, if they can't read, then I think you would be well served. I imagine it's probably going to be a relatively select group of employees. I think you'd be well served to kind of explain to them the notice. So, because at the end of the day, you're going to be asked to show that you've complied with this law. And so if the best you could say was, well, I knew they couldn't read, but I gave them a document that was largely meaningless to them, then I don't know that you're going to be able to show that you at least made a good faith effort to comply with this law. So I would sit down with them and at least kind of give them an overview of what you'd otherwise be providing them in writing. That's an interesting question, though. Julie, go ahead and advance one slide. So, in terms of, because another one of the requirements under AB 685 is that if you have 3 or more positive cases in a 2-week span, then there's an obligation now to affirmatively notify in writing your local public health department. So there was a lot of ambiguity before. There was a lot of questions whether privacy laws allowed folks to share that information, whether they needed to or couldn't or what. This now just makes it easy for everybody. If you've got 3 or more positive cases in a 2-week span, you're required to notify and the public health authorities, and that's kind of considered this outbreak. Go ahead and advance. Advanced slides, Julie. There we go. Okay, so the last thing to know is just in this area is that if you're not carefully managing this stuff and you're not able to show the preventative steps that you've taken, and again, I think you really want to be able to show them via written documents and plans that show you've carefully taken into consideration the unique situation you're dealing with at your workplace. If you can't show that, ultimately, CalOSHA does now have the authority to shut down and issue a stop work order. So just something to think about. If there was any question as to whether OSHA can put that kind of a freeze on your business, it's potentially a risk that's looming out there. So again, you want to be as proactive as you can in not only preventing this stuff, but also being diligent and showing how you're preventing it, and really kind of building your case in advance for all the things you're doing correctly. So let's advance, Julia, and we'll kind of quickly go through.
We're actually getting questions in the chat on that topic, so we'll just hold on to those questions for a minute.
Okay. So go ahead and advance 2 slides, Julia. So we'll get into kind of, you've got the policies in place, you're taking the preventative measures that you need to. What do you do when you've got either an employee who reports to you that they've maybe been exposed, or maybe they're not quite sure, maybe they are sure, but they report to you, hey, I think I've been exposed, or what do you do when you have an employee who says, I am, I'm a positive case. What does that look like? So, in the context of managing potential exposures, we're going to look at the CDC's guidance, and we're talking about a relatively specific definition, right? It's people who you've been in close contact with, so within 6 feet or more or closer, for a kind of a cumulative time period of 15 minutes. So that's a close contact, and a potential exposure is a close contact with an individual who you know, either suspect of being COVID positive or they've been confirmed positive, and then we're looking at that time period from the time the onset of symptoms to 48 hours prior to that. And so obviously that definition kind of is very similar, but it's a little bit different than the one that Cal OSHA is using. Go ahead and advance slides. There we go. So in the context of an essential employer, which ag would be, they would have all essential workers. If those employees have been potentially exposed, they can continue to work provided that they remain symptom-free and you're taking additional precautions. So it's got to be, there's got to be some sort of a combination of, requiring face coverings, requiring physical distancing. If you've got a certain cleaning and disinfection protocol, be able to show that you've increased that protocol with respect to this particular employee. You want to be able to show that you've taken some sort of increased precaution. Go ahead and advance. So once you've got an employee who comes to you and says, hey, I've been, monitoring, doing my self-monitoring or my self-screening, I've now got symptoms, you want to immediately send the employee home. There's no reason to wait. There's no reason to kind of, second guess yourself, whether this, maybe a situation where you need to send somebody home or not. You want to immediately send the employee home, advise them about their options for taking paid sick leave. We'll talk a little bit about those in a moment. Consider whether it makes sense to advise testing. I think a lot of it's going to depend on the circumstances. We've now got this kind of different tiered category for each county. So take a look at your county and kind of consider the degree that your local health department is telling you that you are impacted by this or not. If you're kind of lower down on the scale, maybe it would be sufficient to just have the employee go into quarantine. If it seems like it's maybe part of could potentially be part of an outbreak, then maybe you want to be proactive and go ahead and advise testing. But I think you're going to be looking at your individual circumstances, the availability of testing in your area, how quickly your test is coming back. You're going to want to kind of take in all of the relevant facts that you can given your particular area that you're dealing with. And then, certainly clean and disinfect the area. Then you're also at that point, because you've got an employee who's symptomatic, you're going to have to go back to, the slide we just talked about, and then determine anybody who's come in close contact with that employee in the kind of time frame from the moment they express symptoms to then looking back 48 hours and figuring out who have they worked with and who have they potentially exposed. And then I think you're while you wouldn't be in a situation where you need to provide notice to all employees under AB 685, I think the best practice in this situation is that if you have employees that have been potentially exposed, I think you need to advise them that they may want to take precautions and kind of leave that up to them. If they want to go get tested, that's something they can do. The important thing with notifying employees in this scenario, though, is that you're not identifying and the focus should not be identifying the potentially or the symptomatic employee, right? The focus should really just be on informing the potentially exposed employee that they may have been exposed in the workplace. But again, in terms of maintaining privacy and complying with other laws, you want to maintain the confidentiality of the employee who tests positive or who is expressing symptoms, excuse me. Go ahead and advance. So if you've got an employee then that comes back and is a confirmed positive case, the hope is that the employee should not be working, right? But the reality is when we know that there are, there's some employees who never express, they're perpetually asymptomatic, they never go into a phase of having symptoms. And so at some point, if they've gotten a test for whatever reason, and they find themselves in a situation where they didn't have symptoms, but now they've got a positive case. So if they're working, then they need to be immediately sent home, and you're going to need to go through the steps that you'd go through when you have somebody report that they've been potentially exposed, right? So you're going to go back through and figure out who that employee is in contact with, and you're going to be doing all of those other steps that we just talked about. You're also, if the employee's not working, right, you're going to be considering the timeline of all this and whether they need to continue to quarantine. This is particularly, it's kind of a continually moving target, so you're always going to be having to consider, what's the time frame? Has it been 14 days since their test? And that's going to depend on kind of how soon your local authorities are able to get back test results, because it's unfortunate and varied by from county to county. You'll want to hand out the workers' compensation claim form. I think to the extent you can just remember the phrase "when in doubt, hand it out." You really want to be making sure that you're complying with that obligation. And then in the event that you've got 3 or more positive cases in a 2-week time span, you're going to want to notify your local health authority, because that meets the definition under 685 of an outbreak. Julie, let's go ahead and skip down. I'm going to skip through. I'm assuming that a lot of people have heard about, we kind of touched on it here, but SB 1159 and this whole kind of rebuttable presumption that if a worker has been working, that they may be entitled to workers' compensation. I think that we've covered that a lot, and if not, these slides are pretty descriptive for folks. I want to get to your leaves of absence that are out there. So if you've got an employee who's expressing symptoms and needs to stay out of work, if you've got an employee who's positive and needs to stay out of work, if you have an employee who has to stay home and care for somebody, if you have an employee who's fearful about coming to work because of COVID, the question arises: what leaves might be out there? What time away from work is potentially available to these employees? So regardless of what size employer you are, you're going to be covered under either a state or federal law that are largely duplicative, but have some subtle nuances. So from a federal perspective, if you've got fewer than 500 employees, you're going to be covered under the Families First Coronavirus Response Act. That law is effective until the end of this year. It provides 2 different types of kind of COVID-related leaves. There is the expansion to the Family Medical Leave Act, and so there's potential for 10 weeks of unpaid leave there for the purpose of caring for a child who's at home because their school is shut down. There's also the up to 80 hours of emergency paid sick leave if an employee is out for, and we'll talk about the qualified reasons in a minute, but so you've got two flavors of leave there. And then if you happen to be an employer that has 500 or more employees, then you're not covered by the federal law, but you would be covered by a kind of a state law that was intended as a stopgap, or just sort of intended to cover workers who were not covered by the federal law. So as a lot of our employees being food sector workers, I think a lot of ag employers have been dealing with this since, I believe, April 16 was the date that the governor's executive order that called for California's supplemental COVID-19 paid sick leave for food workers went into effect. If for some reason you weren't covered by that, then SB 1847 has now required that same supplemental paid sick leave be extended to non-food sector workers. So really, regardless of whether you are in a situation of having fewer than 500 or more than, or 500 or more, you're going to be covered by one of these supplemental paid sick leaves. which is going to provide up to 80 hours of paid sick leave for some COVID-related reasons. In addition to those laws, you've also got your traditional California paid sick leave. There's also potentially, if someone was to exhaust those 2 leaves and still need additional leave for a serious health condition, that can trigger an obligation to provide unpaid FMLA or CFRA leave. And then once that is all exhausted, if for some reason an employee was still out, it's possible that you would need to provide some sort of unpaid leave as a reasonable accommodation. So just kind of be prepared to explore all options when an employee has to go out for leave. It's just unfortunately the case that some employees are not affected at all, others are kind of mildly affected, and then there's this kind of select few that have been really seriously impacted by it. So just be aware that there are potentially a number of different leaves that are available. Go ahead and advance. Go ahead and advance 2 slides. There should be a table. There we go. Okay, so in terms of qualifying reasons, you can see that the reasons are largely duplicative, right? Certainly if you're personally subject to a quarantine order from either a local, some sort of local authority or a federal or state authority, then that would qualify. If you are personally subject to a doctor's orders to quarantine, those two would be covered, and you'd be entitled to leave under either federal or state law, depending on what you were covered under. For federal law, they also cover the situation where, and they expressly cover the situation where an employer is experiencing symptoms and seeking medical diagnosis. Now, under state law, while that's not expressly covered, if an employee has symptoms, as an employer, you are required to keep them out of your workplace. And so under state law, you would be under the third kind of qualifying reason. When an employee is prohibited by their employer from working, then they'd be entitled to take paid sick leave or the supplemental paid sick leave. So for the most part, everything is going to be duplicative. The one that is different is under federal law. If you're out due to having to care for your kid who's either out of school because the school's been shut down or their daycare provider is unavailable, then you would be entitled to use federal paid sick leave law, but California doesn't have a component for that. That being said, in the context of just trying to keep good morale, manage your workforce, and kind of keep up with expectations, but a lot of employees that are just confused about when they are and are not entitled to leave. Even if you're not covered by that, you might consider offering that to your employee just as a way of trying to keep up morale and limit the frustration that an employee might feel. Because as we talked about earlier, often the case that the wage and hour cases spawn out of just sheer employee frustration over a situation that they even wrongly perceive as being unfair or a violation of law, even if it's not. So just something to think about. In the interest of time, I think let's go ahead and just open it up for. I see a lot of questions in the chat. So, Julie, I don't know if you've been able to track questions. I know to the extent that folks have other questions about federal or state supplemental paid sick leave, you'll have access to the PowerPoint. The PowerPoint does a pretty good job, I think, of kind of overviewing the obligations. Maybe the one last thing that's important to note is that it's not something where if you give the supplemental paid sick leave, you're able to detract or take away from the California paid sick leave. The employees are always going to have both leaves available to them. Their supplemental paid sick leave, and they're also going to have their California paid sick leave. So you want to make sure you're providing both.
Okay, so we're having a few questions in the chat, and it goes back to the SB 685 and the proposed CFLCA COVID prevention regulation. Okay, so back to AB 685 notice. Will this notice be in effect more immediately if CFLCA passes their proposed COVID prevention regulation being heard at CFLCA Standards Board tomorrow as an emergency regulation? The proposed CFLCA regulation includes AB 685 notification requirements.
That's a very specific question. I think to the extent that you can begin complying with 685 beginning January 1, and really, I mean, even the principles of 685, I think, are something that it's obvious that OSHA is going to be looking to enforce that. So the extent that you can begin putting those steps in place now, I think you'd be better served.
Okay, then we have another question on CDPH. As of November 16, updated their guidance to, quote, people in California must wear face coverings when they are outside of the home unless one of the exemptions, etc. So does that mean we should effectively immediately update our masks policy, or are we supposed to wait for CFLCA's regulation? Our current face mask policy reflects CDPH previous guidance.
That's a great question. I wouldn't wait. I wouldn't wait for CalOSHA's regulations. I think because there is a now state requirement that folks be wearing face coverings, except in a very kind of limited circumstances. I mean, in essence, it's requiring face masks or face covering anytime an employee is outside of the house and not able to physically distance from people who are not their family. So if you've got, if for some reason you had a group of employees who were all from the same household, then that's fine. You could, they'd be exempt from having to wear face covering. But by and large, the majority of the circumstances that you're going to face are going to be groups of employees who are outside and they're with people who are not in their households. So then the next question is going to become, can they physically distance? Can they maintain 6 feet apart? And if the answer is no, if the work that they're doing requires them to be within 6 feet, then you're going to want to require a face mask or a face covering.
And we have a question from Lupe on CDC slide. Is it 15 consecutive minutes or 15 minutes of exposure over the workday?
So that's one of the confusing things. The CDC has said cumulative. So from a technical standpoint, if you had, 15 one-minute interactions with somebody in, close proximity, so inside of 6 feet, then CDC says that would kind of, meet the requirements to deem that a close contact.
Okay.
So in the context of interpreting everything to the benefit of the employee, I think that's the way you want to apply it.
Thank you. And we have another question. If an FLC crew on your property has 3 or more positives, will that expose the grower to a possible shutdown?
Possibly, yeah. The reality is there hasn't been clear enforcement, at least from what I've seen, county to county. The way that local health authorities are interfacing with local district offices for CalOSHA has been a little bit different, depending on where you are. And so it would certainly be possible. So I think to the best you can, I think you want to actively manage this stuff. Take the steps that you can to prevent it from cropping up, because it's a lot of it's unclear how counties are enforcing it. And I think there are many local health officials who are just concerned about ending up in the news, and so they're in the interest of kind of covering their own liability, they're maybe taking steps that are more aggressive and more going further than what CalOSHA's guidance is even recommending. So I think, yeah, you can certainly find yourself in that situation. So it's not something to just say, hey, we're the grower, they're the FLC, therefore we're not going to have to worry about it. If they're on your premises, then I think you need to treat them as somebody that you need to be applying these principles to, or making sure that the FLC is applying all the preventative measures to.
We have another question on face coverings. Regarding face coverings in a workplace where we aren't generally open to the public or visitors, but a few of us sit out front where employees comes through during the day. Is a covering required at all times or only when an employee is walking through the open area?
Say that last part again. Only when the employee is in the.
Are the face covering required at all times, or only when the employee is walking by in the open area, by those people that are sitting up front?
So the face coverage would be required anytime you're outside of the house and unable to physically distance. It's kind of the short answer. There's some specific exceptions to that. If you're under the age of 2, or if you're someone who has a medical condition that prevents you from wearing a face covering, then there may be an exception to that. You may be able to put a face shield on. But for the most part, if you're outside of your house and you're unable to physically distance, then you, according to the CDPH, are required to wear a face mask. But again, if you can physically distance, for example, one of the exceptions is that you work in an office and you're in a room by yourself. That would apply to me. I'm in a room, I'm by myself. I work in an office. If you're in a car, right, if you're carpooling with only members of your household, then you don't have to have a mask on. But if you're outside of your house and you can't physically distance, and you're around others that are outside of your household, then you're probably going to fall under that area where you need to be in a face mask, according to the CDPH.
Thank you. And now we have more of a few comments. Lucas Sandoval says, Housing for Harvest program offers free housing, hotel for ag workers on quarantine in certain regions. Should employers look into this as benefit for workers?
I honestly have not looked into the Housing for Harvest program. I know that it's out there. I haven't heard anything about it. But I think there's been a number of different counties even that have done their own local initiatives to try to assist ag workers in being able to avoid creating an outbreak, but also continue to participate in work. So I would look into it. I think that's for anybody who hasn't heard of the Housing for Harvest program. There's the CDPH's website, CalOSHA's website, I believe, has a lot of guidance documents and a lot of information about that particular program.
And we have another comment on proposed CalOSHA regulation on COVID. It also requires employers to provide free COVID tests to exposed workers along with the notification. And that's back to the proposed CalOSHA regulation.
Yeah, I mean, to the extent that a regulation's been proposed and hasn't gone into effect, it's not the law. At the same time, it's an indicator of kind of where an agency believes the law should go. So I think you should consider it in your response to this stuff, and certainly if you're dealing with a particular situation, if you're requiring an employee to get a test, right? If it goes beyond just, hey, you've been potentially exposed, you might want to take precautions. If it goes beyond that, for you saying, hey, we're requiring you to go and seek medical attention, then I think you need to be providing the payment for that. And then you've also got to think about that if they're going to do that at your direction, is the time that they spend going to get medical attention, is that, and should it be compensable work time? Are they under your control? So again, if you're required as a condition of employment, I think there's a good argument that not only do you pay for it, but it's probably hours worked. To the extent that it lands you in one of those gray areas, I think you just go back to your golden rule and really ask yourself, is this the hill we want to die on, with putting our foot down and not considering this hours worked, not paying for it? Because if we're wrong, and we might be, well, then it's going to have potentially a lot more negative ramifications for us than just paying for this test and paying for the time it takes to go get it on the front end. So again, always interpreting things to the benefit of the employee, or in a way that's most restricted to the employer. That's kind of the way you guarantee yourself you're going to stay safe in the interpretation of these principles.
Well, and that's all the time we have for today, Seth. Thank you so much for this great presentation. And the session chat will be available after the presentation, so feel free and continue chatting. And once again, we would like to thank all the sponsors of Ag Labor Forum and Barsamian and Moody and Seth for this presentation. Thank you so much.